now into the Polish society, legal mobilization against authoritarian backsliding following the abortion law. So the lecture is part of our speaker series on the post-1989 democratic transition in Poland, and the series is co-organized by the Polish Study Center and the Robert Burns Russian and East European Institute. So I would like to also thank the REI for co-organizing this lecture, and especially the chair of the institute that is here, Sarah Phillips, Professor Sarah Phillips. The talk is also co-sponsored by the Institute for European Studies, for which I would like to also thank. And I'm really thrilled to welcome our distinguished speaker today, and our speaker is Agnieszka Kubal, Dr. Agnieszka Kubal. And Dr. Kubal is an associate professor at the School of Slavonic and East European Studies at the University College London. And she's an interdisciplinary social, legal, migration, and human rights scholar. As for the area of interest, Agnieszka focused on Central Eastern Europe and Russia. So Agnieszka is an author of two monographs, Social Legal Integration, Polish post-2004 EU Enlargement Migrants into the UK, and Immigration and Refugee Law in Russia, Social Legal Perspectives. Recently, together with Marina Kurkichian, Agnieszka co-edited a volume on sociology of justice in Russia, and this volume was acclaimed by the critics as the most analytically sophisticated and empirically rich volume ever produced on the everyday operation of the Russian legal system. So congratulations for this, Agnieszka. And Agnieszka, we have really great pleasure to host you here. Thank you for coming. And yes, without further ado, the floor is yours.
Thank you very much, Justyna, for this lovely introduction. I'll hope to live up to it. What is Skarga Kobiet, or Women's Complaint? It's basically an application to the European Court of Human Rights that was filed by over 1,000 Polish women following the decision of the Constitutional Tribunal. And I want to put it in a broader perspective, as it's not only about women standing for their reproductive rights, but also through this complaint, they are standing or mobilizing against the authoritarian backsliding more broadly. Because, of course, reproductive rights and rule of law are intricately linked. But before I talk about the paper, I wanted to use the opportunity, because this is my first time at Indiana University, to sort of introduce myself and where I'm coming from to this research. So my PhD looked at Polish migration to the United Kingdom, as Justyna already said, but I looked at integration sort of beyond in the mainstream debate. Law and the relationship with the law of migrants was sort of either taken for granted or not really explored much further. So I looked at how Polish migrants build a relationship with the rules and regulations in the United Kingdom, and within this framework of social legal integration. And for that, I conducted interviews with migrants who had to sort of navigate the system, but also I have served as an interpreter in a legal aid NGO, where I was interpreting in the Polish cases, but also later on they trained me to become an advisor, particularly with regard to the labor law, which sort of was intrinsically linked with welfare provision. After that, I stayed within the region. I moved to Ukraine to do research on migration of Ukrainians to various European countries. It's 2012, and already at that time, some scholars would dub Ukraine Europe's Mexico, for a lack of a better term, because the Western Ukraine was sending a lot of migrant workers not only to Poland, but also to Spain, Portugal, and Italy, the UK to a lesser extent. But I didn't research the migrants in those countries, but I wanted to research the return migrants and the families of people who migrated, to see how certain ideas about law, rule of law, what justice is, what human rights circulate through migration. And that sort of gave rise to my paper on social remittances or social legal remittances, when I'm drawing on the scholarship of Peggy Levitt around social remittances. And yeah, I'm not not saying this, it all can be attributed to my research, but 2 years later we had the Revolution of Dignity in Ukraine. After that, I moved to Russia. I was based at the Center for Social Legal Studies at Oxford, but I was again interested in how migrants build a relationship with the law in Russia, which was already then a hybrid political regime. And Russia was the second largest destination for migrants globally after the United States. The migrants primarily came from Central Asia, so Tajikistan, Uzbekistan, Kyrgyzstan, but also it was after 2014, which means after the annexation of Crimea, after the war in Donbass, which means a lot of Ukrainian refugees came to Russia, and Russia was also an important political player in the Syrian civil war, and there were around 10,000 Syrian, according to the UNHCR, people of concern in Russia at the time. And I was interested in how they applied for refugee status, when that status was denied, what were the options of appeal. And quite often, the lawyers told me that the only way to seek justice was to go to the European Court of Human Rights. Russia, of course, then was still a member of the Council of Europe. And a lot of those immigration and refugee cases actually ended up in Strasbourg. And that sort of gave rise to my current project, because when I looked at the statistics of the European Court of Human Rights, citizens only of 5 Eastern European countries, Russia, Ukraine, Hungary, Romania, and Poland, submit more than 50% of all the claims to the European Court of Human Rights. And of course, the easy explanation would be, well, the human rights record of those countries is not very favorable, so of course. But at the same time, just because your human rights are violated doesn't mean you're going to push back against this. So there's, I think, a very interesting and intricate process of translating one's grievances in human rights terms that is happening in those countries. And that's something I want to explore in my current project, which I'm very sorry for the tabloidy title, but we all play this game with the funders, who are the humans behind human rights. So I'm interested in the sociological exploration of the people behind those cases. So those who put those cases, but also lawyers, judges who adjudicated at the different levels of the domestic system that basically push the case to the European Court of Human Rights because they don't see that particular lobbying. And Magda Mierzewska, who is a Polish lawyer of 25 years at the Polish section, she told me in an interview in Warsaw, I always wanted to find out who were those people behind all those cases. So that gave additional boost that, perhaps what I'm doing makes a little bit, some tiny bit of sense. So now I want to move, so this is the sort of framework from which this paper comes from, that approach, looking beyond those cases and interviewing the people beyond those cases. So in the immediate aftermath of repealing Roe versus Wade, many commentators fear a negative backlash for women's reproductive rights globally. But I would say that looking from a perspective of democratically backsliding Eastern Europe and Poland in particular, this backlash has already been taking place. In October 2020, in the middle of COVID pandemic, the politically controlled Constitutional Tribunal, which according to Sadursky is a reliable aid of the government and parliamentary majority, struck as unconstitutional a right to terminate pregnancy on account of severe and irreversible fetal impairments. And it has to be said that since 1993, Poland had one of the strictest abortion laws. So abortion was banned, and only in 3 circumstances it was allowed. So first, when there was a danger to the woman's life or health. Second, when the fetus had severe irreversible genetic abnormalities that could lead to the death, and by extension, the death of the woman. And the third, if the pregnancy was a result of incest or rape. Only those 3 conditions. So this decision of Constitutional Tribunal effectively banned the second condition. And it has been under thorough critical legal and jurisprudential scrutiny. The various authors pointed to the considerable defects of the legal argumentation that, according to Gliszczyńska-Grabiec, cast a big shadow upon the formal and procedural correctness of the judgment, but also about the closing of the jurisprudential horizon, that is the reduction of the role of international human rights debates as a reference in Polish constitutional jurisprudence. After the judgment, a series of street protests took by storm many Polish cities and towns. It started slow like this, but a week after the decision, on 30th of October, there were around 100,000 people in Warsaw itself protesting this. And the research among the protesters demonstrated anger and dismay over this decision, also among women who declared themselves as Catholic. And with this paper, I want to focus on the sort of untold story of the Polish abortion crisis, a productive rupture that channeled the protesters' efforts into mass legal mobilization against that constitutional tribunal decision to the European Court of Human Rights. These applications are known in Polish as Skarga Kobiet, or in English, Women's Complaint, and they were filed by over 1,000 Polish women, aided by human rights lawyers and activists. You can see here each woman submitted the claim in her own name. And there were two types of women who submitted the claims. First, if a woman wanted to be pregnant, wanted to have a child, but was afraid that as a result of her pregnancy she might be denied access to medical care. And the second type of women who complained were those who were pregnant, and at the time of the Constitutional Tribunal decision, their fetus had severe genetic abnormalities, and they could not terminate the pregnancy, or they had to go abroad to terminate the pregnancy. So here you can see women signing, at the post offices, but also in their own homes, filling in that application to the European Court of Human Rights, which was sort of pre-filled by the lawyers with the legal arguments, and I'm going to come back to this later on. But the core of the complaint relies on Articles 8 and 3. So Article 8 of the European Convention of Human Rights, the right to respect private and family life, and Article 3, prohibition of inhuman and degrading treatment. And the applicants complained, in essence, that they were potential victims of a violation of their rights, as if pregnant, they would have been obliged to carry their pregnancy to term, regardless of whether their fetus had severe and irreversible genetic abnormalities. The first 12 cases was communicated by the European Court of Human Rights in lightning speed, I would say, 6 months after filing the complaint. And you probably think, what is she talking about, 6 months, lightning speed, is she crazy? But we have to remember that the European Court is like the court of the last instance. It has a huge backlog. For instance, cases regarding civil partnerships for same-sex couples from Poland have been, around 20 cases have been submitted in 2017. They were deemed admissible by the court, but we're still waiting for a decision 6 years later. So 6 months for a communication of a decision, and communication means that the court said, well, this is an important case, I'm going to open it up and I'm going to ask the government to send written observations onto that particular case. So that means the communication stage. And a year later, so 6 months ago literally, the court communicated another 5 cases of women who were pregnant at the time of the decision of the Constitutional Tribunal and had to terminate their pregnancies abroad. At a theoretical level, I use Women's Complaint to engage with some of the core debates in law and society scholarship around law as a mirror of society thesis. The main argument I advance in this paper is that Women's Complaint provides not a mirror, but a window or sort of a lens into the Polish society, whereby the mass legal mobilization affords unique glimpses into the ills of the prolonged constitutional crisis. Reproductive rights and democratic values are inextricably linked, and threats to one reinforce threats to the other. Polish women of reproductive age have become the first socially visible group victim of the deformed legal system under the illiberal Law and Justice Party rule. But Polish women do fight back. And this paper therefore contributes to the scholarship of legal mobilization under increasing authoritarianism, whereby Women's Complaint sets an important precedent of counter-legal mobilization against illiberalism. In terms of my methodology, well, basically this is how the complaint looks like. It's 60 pages of a text pre-filled in. So the print comes from the lawyers and the handwritten comes from every woman who had to explain how this decision affected her in particular, so the factual background in other sense, the factual circumstances. And following this sort of humans behind the human rights, I spent around 5 months in Poland and conducted 40 interviews with women who filed this complaint human rights lawyers, legal experts, and women rights activists, and I have complemented it with legal desk-based research where I looked at the text of the complaint, where I looked at the analysis of the decision of the Constitutional Tribunal, as well as other cases to the European Court of Human Rights from Poland concerning reproductive rights. So there's a long-standing, so moving to the theoretical sort of lens or frame, there's a long-standing, perhaps now even a little bit tired debate in law and society scholarship whether law is a mirror of society. It's been advanced by Roger Cotterill, Brian Tamanaha, James Watson, or Lawrence Friedman. And its main argument has been succinctly presented by Tamanaha in the Journal of Jurisprudence of Law and Society, where he says that the legal theory instructs us the law is a mirror of society that functions to maintain social order. In this standard understanding, the norms of law are derived from and reflect the customs and morality of the society. But is that really so? Especially if applied to the decision of the Constitutional Tribunal, when we compare this with the actual social surveys and representative surveys of the Polish population. For instance, in November 2020, so just a month after the decision of the Constitutional Tribunal, SOPOS, which is, I think, the most authoritative polling agency or research agency in Poland, actually you have 64% of the population agree that termination of pregnancy should be permitted by law when prenatal tests show that the fetus is burdened with incurable disease leading to death. So basically the core about which the Constitutional Tribunal decided it's not necessarily, that it's unconstitutional. And no new polls have been published since then to contradict this trend, meaning that it remains stable. Furthermore, 8%, according to census, of the Polish population actively took to the streets to publicly object the decision of the Constitutional Tribunal, while 63% declared their support for the protest. And this means that in the first week, okay, so 8%, well, what is 8%? What does it mean? But in real terms, it actually means 2.5 million adults going to the streets in the middle of the pandemic with the restrictions of gathering, so them risking more than under normal circumstances. And it's, I would say that this 2.5 million estimate by SEBOS is actually it's underestimated because the survey has been done on representative adult polls, while we know that a lot of people aged 16, 17 took part in those protests as well. So why are we stuck in this jurisprudential idea of law mirroring society? I think it comes from the fact that those jurisprudence scholars do not take society seriously enough. Dominant contemporary scholars like Tamanaha, for example, reject the notion of society as an analytical concept and prefer to use society as a shorthand for a discrete group of community unified in certain essential aspects: language, culture, politics, geography, tied at the broadest level to the state. So that's not only very generic heuristic, but that also ignores all the literature about social conflict and social political conflict. And I think based on this weak theorizing, any resultant sociological approaches to theories of law remain profoundly asociological, non-empirical, as they do not take society seriously enough. And this lack of due attention to the various and rich empirical studies of how complex societies work, both historically as present, is expressed through observations which I think are excruciatingly oblivious to social conflict. Many legal systems throughout history have imposed systematic legal disabilities of women, not because men intentionally designed the law to subjugate women, but because under prevailing beliefs, the laws are believed to be right. I can't believe Tamanaha was really allowed to publish it in 2022, because what about the gender conflict in a patriarchal society over political, property rights, citizenship, bodily autonomy that was expressed by different waves of feminist scholarship, which seem to be dismissed in this literature because male standard, dominant in the jurisprudence, has defined into oblivion any version of rationality but its own. And this approach legitimizes discrimination as if sexism was a mere legal error and not a matter of conflict and domination in society. Analyzing the claims of Polish women submitted to the European Court, in turn, takes us deep into the social fabric and allows for a more nuanced sociological observation of the current conditions of the Polish society. So let me now move to this, my empirical material and how this complaint actually came about. So in the days following the announcement of the judgment in October 2020, a small group of women coming from different walks of life met online to discuss whether there was any way they could respond, express their dissent, and ultimately stop this abortion law. So they told me, this complaint arose out of gigantic anger and a gigantic no way. And this is how it started. The women met in anger, in despair, and decided we can't leave it like that. We had to say stop and do something about it. It was anger, we felt cheated. So it's a relatively small quote, 3 sentences. You have the word anger 3 times. Honestly, don't mess with angry Polish women. And these women started a grassroots movement and a social media group under the title Women's Complaint, alongside taking part in street protests in towns and cities. Overnight, despite this being a closed group, it received more than 20,000 people, and within a week there were 54,000 members. But the women needed a critical ally, someone proficient in the knowledge of legal routes, procedures, options for appeal. In Lisa Van Hala's terms, these women needed strategy entrepreneurs, agents who might play a role in introducing new tactics into an organization's repertoire and promote the use of particular strategies such as legal mobilization. And this ally came from a second group of women, human rights lawyers, who were organizing in parallel via an encrypted group on a popular social media communicator. All the human rights lawyers were women who had previous experience of applying to the European Court of Human Rights. They represented applicants before the court, were proficient in preparing and framing a text of the complaint. And these lawyers worked in the past in the European Court in professional capacity, sometimes for many years. And one of these lawyers was an absolute leader in terms of the cases before the European Court of Human Rights, which she brought from Poland. And she also represented applicants in the majority of the previous reproductive rights cases. So once this initial contact was made, the work on this women's complaint proceeded in 2 parallel routes. The human rights lawyers were preparing the text of the complaint, while the social activists were responsible for the broader social media communication. And they told me, these 2 orders, legal and social media, we had to juggle between them. They follow different rules of the game. They require completely different modes of work functioning. It is known that the legal order needs patience, analysis, long periods of time. And we all know that social media, the internet, well, if anything, they are not patient. So the everyday work between the lawyers and the women activists relied on negotiating or translating these 2 different realities. On the one hand, this meant that activists took on the role of decoding professional legal concepts into everyday simple language so that the text of the complaint could be understood by all the members within that social media group, the potential applicants before the European Court. So they told me, we knew that our messages should be understandable to someone who is 40, has primary education and lives in Radom, and to a girl who has just completed her A-levels, just for everyone. On the other hand, this also meant that the activists actively negotiated the shape of the complaint, while they left the text to the professionals. In the final version of the petition could not be too long, as it would reduce the chances of it being completed. So it's not just simple mobilization of lawyers driving strategic litigation to the European Court. You can really see how the social activists were involved in shaping the complaint. So one activist remembers how the first version of the complaint was 300 pages long because of all the appendices that the lawyers wanted to meticulously attach as evidence. And this was a watershed moment. She said, it nearly broke me. We could not expect that women in Poland would be willing to pay, that's $12, for the postage to Strasbourg. So while the actual complaint was 12 to 15 pages long, these practical considerations resulted in redrafting of the attachments, changing some to URLs, so that the final complaint ended up approximately 60 pages. And this demonstrates that the process of legal mobilization surrounding women's complaint depended on this nuance, the 2-way social legal translation. First, and what is standard in legal mobilization cases, the lawyers translated activist anger and grievances into achievable human rights claims. But the second, the activists themselves had to translate the complex legal language from the text of the complaint into a clear message that had a mobilizing potential among the women who were to ultimately file these petitions, each under their own name. The text, I would say this was ultimately a success because the text of the complaint, according to this NGO, women rights NGO, has been downloaded more than 8,000 times. Women applicants were to send their petitions individually, but some treated the act of posting as an active form and extension of earlier protests. So for instance, they took pictures of themselves at the post offices, clearly addressed envelopes to the European Court of Human Rights. This was accompanied by, I would say, the main statement that concerned this women protest. You will never walk alone. Nigdy nie będziesz szła sama. And the women in this medium-sized city of Gliwice, which is like, in southwest Poland, in Silesia, they appeared at the post office with this, huge envelope clearly addressed to the registrar. And that sort of made the lawyers and social activists aware that this petition has penetrated different corners and contexts of Poland, and it was not limited, to this urban centers and, educated women of Warsaw, Kraków, or Poznań. Also, several left-wing women MPs also took part in this campaign. They opened their offices for women to print that text of the petition free of charge. They provided space for them to complete it in their own name, and the MPs also completed the petitions, each in her own name, and posted the pictures on social media. And this further raised awareness of this campaign and the European Court of Human Rights in particular. One activist told me, I think we have all learned a lot in the process about what the European Court of Human Rights can potentially do. I think many of us have felt incredibly empowered. We felt there was some legal body that could help throw the life buoy. I think it was of great importance for the identification in this institution. But why do I say that this is more than just women standing for their reproductive rights? I think it's because if I now move to the legal analysis of the text of the complaint, majority of it focuses on the rule of law and procedural deficits in the abortion law, thereby making an argument that the interference with the right to private and family life, so Article 8, did not happen in accordance with the law, was not necessary in a democratic society, and breached the state's positive obligation. The argumentation concerning the rule of law irregularities, it rests on three pillars. They are really complex because when the politicians made such a mess out of it that it's very difficult to explain, but I'll try to do it very succinctly. So first, the decision of the Constitutional Tribunal we have to remember that it took place after months and months of dismantling the justice system by the ruling coalition. As a result, the text of the complaint stipulated that decision was issued by a tribunal which, in the light of the law, was not a legitimate court. It was not a court according to the law. The composition of the tribunal included 3 judges that were not supposed to be on the bench. In other words, they were sitting in place of judges already elected by the Polish parliament in the previous term, but who were never sworn in by the president, because the president was the ally of the new ruling coalition, right? So the judges who delivered this decision, they were not elected in empty spaces on the bench. No, those spaces have already been taken. So we see a political conflict at play here, which leads to legal dualism in Poland. And the validity of this argumentation was later confirmed in another case, Xerof Law, of the European Court, where it stated that the appointment of judges to Constitutional Tribunal was characterized by grave irregularities, rendering the bench unlawful and not a court, according to the law. Second, the text of the complaint highlighted a potential conflict of interest concerning one particular judge on the bench. So in 2020, she was a judge on the bench and she co-written the majority decision. However, a few years back, she, still as an MP, wrote a nearly identical petition to the Constitutional Tribunal to check whether the access to abortion on account of fetal genetic abnormalities was constitutional, was in accordance with the Constitution. Because at that time, the Constitutional Tribunal was still independent or semi-independent, that motion was dismissed. However, a nearly identical motion was filed when she was on the bench. So, do you see a conflict of interest here? Like, basically, she was marking her own homework, right? She had vested interest in that motion being declared unconstitutional. And the human rights lawyers raised an argument that deferring the issue of reproductive rights to Constitutional Tribunal demonstrated that the government used the tribunal as a substitute for legislature, right? So the Law and Justice, they wanted to avoid the responsibility for this thorny issue and solve it through the back door of the politically controlled Constitutional Tribunal, which did not have the social and political legitimacy to address it in the first place. The matter of such grave importance as, the most popular avenue for abortion should have been debated before the Parliament and more widely in the society. Instead, we have seen a reversing of the roles of important state organs or institutions. Constitutional Tribunal, by limiting women's reproductive rights, has effectively acted as a substitution for the legislature. And it is not surprising, therefore, that this sort of three arguments took over 75% of the text of the petition as the primary justification for violation of Article 8 European Convention. And the lawyers consciously exploited these developments around the abuse of the rule of law in framing and structuring the arguments pertaining to the abuse of private and family life. So, taking it all together, the theory and the sort of empirical analysis, why do I argue that at an analytical level, women complaint could be seen as a window into the society? The legal mobilization behind women's complaint provides three important insights into the depths of the Polish societal fabric and contributes to social legal research in foundational ways due to, as Chu says, authoritarianism's ubiquitous nature. First, it shows a society in a state of deep conflict over interpretation of human rights. While the women applicants to the European Court saw the Constitutional Tribunal decision as a curtailment of their rights, the opposite was being claimed by the conservative MPs whose petition resulted in the abortion law. Their motion was to determine whether right to terminate pregnancy due to severe and irreversible fetal abnormalities was compliant with constitutionally enshrined rights to dignity, that's Article 30 of the Polish Constitution, and protection of life, Article 38, or whether it resulted in the so-called eugenic abortions. So in other words, the motion was arguably about more human rights rather than less. As Koralewska and Zielińska pointed out, however, in their analysis of the right-wing conservative media discourses, the main themes that dominated the debates about abortion were the protection of the unborn, protection of women. And this protectionist language reflected a wider adaptation of the anti-abortion discourse to reclaim human rights from their liberal origins. So human rights at the moment have become a battlefield of different ideological explanations. And one lawyer told me, human rights, especially nowadays, in times of populism, when constitutional orders are really political orders, human rights can mean anything. Oh, I see very clearly the logical flips or cruelty of these arguments. The conflict that engulfs Polish society, however, goes deeper than the interpretation of human rights and concerns many other aspects of social and political life. Women's complaint illustrated the extent of the rule of law deterioration and a constitutional crisis, but also a popular resistance against this illiberal turn in Poland. Women activists further highlighted how women's complaint cannot really be separated from, but builds on the other protests in the Polish society concerning the quality of the justice system. So they told me, with this action, we wanted to show how important the rule of law is, how important the courts are, and how important it is to have access to those courts that are independent and free. Or this activist, the institution of independent courts is crucial for our safety, for the safety of Katarzyna, 20-something from Skierniewice, and Hanna, a mother of two from Szklarska Poręba. It was very important to us too, otherwise there wouldn't have been so many of these complaints. And I think I would sort of venture a statement or a conclusion that this is quite unique to Poland. We have another society which undergoes democratic backsliding in central Hungary. But there the judiciary is considered almost like a separate political or no, professional body outside of the society. We haven't seen these rallies and marches in support of the independence of judiciary in Hungary, which, you know, when you talk to people, they say, okay, so the judiciary, they are in conflict with the government, but this is their job. While in Poland, I think the judges really done a great job in engaging, saying, look, we are on the front line, but if we fall, you know, this will be the independence of all the courts. This will be cases, you know, everyday life cases about divorce, about adoption, that will be at stake here, right? Finally, I think women's complaint also exposed the ruling by cheating strategies of the incumbent government. And this ruling by cheating I borrow from Andras Sajo, who, a Hungarian constitutional scholar who in his book Ruling by Cheating, Governance in a Liberal Democracy, he traces in detail the process of advancing populism and democratic backsliding in Eastern Europe to arrive at this theory of cheating in constitutional law. And this is because, I quote, with illiberalism unleashed, populism in power turns its action against constitutionalism, whereby, and I quote again, democracies that emerge from populism are ruled by all efforts to conceal the truth in order to mislead. So how does this ruling by cheating translate into the present Polish context? What should have been a legislative decision preceded by popular social consultations around the consequences of delegalizing the most common avenue for abortion became a judicial decision of a politically controlled tribunal. As Sajo explains, illiberal regimes relying on systemic cheating seems to follow specific rules of positive law strategically and selectively, and again pretend to satisfy the requirements of the rule of law, but they do so in disregard of the relevant standard or principles of the spirit of the law. So in different works, Kim Lane-Shepele called it a Frankenstein law. So like different parts and pieces might be okay legally, but altogether it seems to lead to, you know, this Frankenstein figure, like a travesty of justice. So this is exactly what happened in Poland, because while the motion to the Constitutional Tribunal by the MPs are perfectly legitimate tools in themselves, they become a joke if the said Constitutional Tribunal is not a court according to the law and is politically controlled. So by listening to women explaining reasons for legal mobilizations, like we felt cheated, and studying the legal argumentation behind the European Court's petition, in this paper I wanted to show that women's complaint clearly demonstrated how the Law and Justice Party delegated the issue of socially controversial abortion rights to politically subservient judiciary. In exposing this cheating, women's complaint from a reproductive rights has become a broad rights-based litigation against the rule of law crisis in Poland. Right? So to conclude, women complaints tell the story of women standing for their reproductive rights and in effect spearheading a much broader rights-based litigation against authoritarian backsliding in Poland. And this mass-scale mobilization to the European Court of Human Rights following the abortion law revealed how women's reproductive rights are intricately linked with rule of law. Women complaints cuts right through the deep-seated conflict between the significant section of the Polish society and its government, challenging the thesis about the law being a mere mirror of society. Complex modern societies are never unities that could mirror the society, the law as a whole. And this supports my analytical stance of methodologically treating examples of legal mobilization in Eastern Europe not as a mirror of society, but as a window into the society, capable of providing unique glimpses into the specific characteristics of the social fabric. So more than 1,000 women standing for their reproductive rights has become a prime example of rule of law litigation before an international court. But I also think it's a cautionary tale that authoritarian attacks on domestic independent courts are, in fact, attacks on the entire societies. Thank you.
Agnieszka, thank you so much. It was a fantastic talk, and thank you for doing this important research on the current issues that are going on. I think that we've got the time for the discussion. So
Agnieszka, so it means that this complaint is still reviewed by the court?
Yes, yes.
What instruments the court has? So what the court can decide?
So the court, so we already have jurisprudence that develops around many of the arguments that the lawyers raised. So for instance, the lawyer said that the Constitutional Tribunal who delivered this law is not a court according to the law, and indeed they submitted this claim, and 6 months later we have a different case which decided exactly that. So there is a precedent to follow. So I believe these cases will be successful, and the courts can do two things. On the one hand, it can order individual measures, so basically award the women a compensation. It's not going to be a big compensation like in many, I don't know, US tort cases, but it's going to be, from a couple to, I don't know, 30, 40,000 euros, depending on the type of grievance that was raised and the severity of the violation. And the second, the court can order general measures. So it can say to the state, guys, you need to change this law. This law is in flagrant violation of the European Convention. This law has to be amended. So the way we look, different countries from the Council of Europe interact with the court, they usually pay the compensation straight away because, even Russia always paid. But it's more difficult when it comes to actually implementing these general measures because that requires political will on the side of the state. And this is why now is such an important year. It's the election year, which will probably, decide whether. I'm thinking the European Court of Human Rights is strategic. It's going to wait with the judgment until they know the court knows they're going to be implemented. And I think it's the same with, for instance, the LGBT cases or the civil rights union. There's no point of deciding them now because they will not be implemented within the current political scenario. No?
Especially with the Council of Europe, the Venice Commission has already said that there is this violation of the rule of law. So
Yeah.
it was not. There's not implemented.
Are there enforcement mechanisms or no?
So the idea of the Council of Europe was that the countries joined because they genuinely want to do better in human rights terms. So nobody was forced to join. It was an application process. So the Eastern European countries joined after 1991, but the court sort of was established in 1951, and with the idea that we all joined because we wanted to do better. And what looks at the body that looks at the execution of the judgment is the Committee of Ministers. So each of the countries of the Council of Europe, which spans from Portugal to Azerbaijan, Armenia to Norway, has got their own ministers of justice, which together, sort of in a very consensual way, see how the enforcement of those judgments is proceeding. There are also bigger sanctions, like for instance, after the annexation of Crimea and the war in Donbass, Russia was, for instance, suspended in the Council of Europe. So it didn't have a voting right in this Committee of Ministers. But then in 2019, it was brought back. And now in 2022, it was completely kicked out. I mean, of course, we have a forced-scale invasion, the anniversary of which is tomorrow in Ukraine. So there was unprecedented sanctions and the threat of expulsion from the Council of Europe, to which Russia said, you know what, we're leaving. We don't need to be kicked out. So in 15th of March, the Russian Minister of Foreign Affairs issued a letter that we're leaving. And on the 16th of March last year, there was a vote that Russia should be excluded. So it was very two eventful days in the Council. But that's basically the severity of the sanctions. If I can just make a quick comment that I think the exclusion of Russia was a political move, and politically it was very important. But actually, given that more than a quarter of the applications to the European Court of Human Rights came from Russian lawyers and citizens, this has really closed an important avenue for justice for them, right? I got we had to protest, not big protest, but nevertheless, end to the war, end to the war. Lots of people were arrested, and I got a text message from a friend of mine who was representing the applicants in those cases at the domestic level. So, and he said, look, I'm sitting in this court 6 hours already because there is a delay, and before 15th of March, I could see that, there was hope. A few years down the line, the European Court will say that this is black and this is white, But now, there is just no point me sitting here because I know what's going to be the decision, and there will be no way of appealing that any further. So, I mean, there are various debates. Like, for instance, my Polish lawyer's friend will say that no, it was time to get rid of Russia from the Council of Europe in blatant violation. But I actually think this is a much more gray area because the people who are actually really losing from that are the applicants. If the state can ignore it, they would.
Yeah.
So thank you, Agnes. This was fascinating, and I learned a lot about things I didn't know very much about. So thank you very much. So I'm just trying to think across contexts here, both and admittedly different political contexts, but some of the phenomena you described are resonating with me. So I want to give 2 examples, and I'm just really curious to hear your thoughts. So one, thinking about the first complaint, which is that this was an illegitimate court, right? And I'm thinking about ways that changes in the composition of courts can be used to advance, as in this case, illiberal laws, but they can also be used to advance what we might think of as progressive laws, right? So is it the framework in which those changes are taking place that matters? Or I'm just trying to think aloud about how we might address this. I'm also thinking about the US context where there are calls to expand the number of justices on the Supreme Court, potentially as a way of also getting beyond some of the deadlocks that have emerged, right? So there's that issue, and I'm curious to hear what you think of that. And then there's this other question about courts as a substitute for the legislature, right? Because let's just take LGBTQ rights. We've seen globally, I think, more examples of advances through the courts than necessarily through legislators, because legislators are held to electoral constituencies, et cetera. Now, that's not always the case, but so there is that dynamic that I'm curious your thoughts on in terms of courts necessarily being a second best to legislative decision making. And obviously this has to do with the independence of the judiciary as well. So I realize there are complicating factors here, but I'm just going to throw that out there.
No worries. I think these are really, really good comments that make me think about how to do the paper. So in terms of the framework, I would say that there are constitutional rules and procedures like that derive from the rule of law that should be followed. In Poland, the judges to the Constitutional Tribunal are elected by the parliament and sworn in by the president. So Law and Justice, because they won the elections, if they just waited for the end of the term of the different judges, they would have got there anyway. But the fact that why this has been pronounced not a court according to the law is just they just messed it up. They wanted too much too quickly, and they just really did it in blatant disregard for the procedures and the checks and balances, etc. So I think it's difficult. I think it brings us into this broader discussion about when the courts are. I mean, the courts are obviously not democratic bodies because they are elected by the parliament. So the judges are elected by the parliament. So sworn by the president. To what extent can we say that then they can pass different laws? And the judges are, I think, very aware of this. So part of this research is I talked to judges and I asked them, so there was this LGBT case in front of you, why you didn't like it follows the jurisprudence of the European Court of Human Rights. You could easily, say that, these two women, when they were married in Berlin, they don't have to at least lie to put on any forms in Poland that they are single. And the judge is very aware, saying, sorry, I can't step in the role of the legislator. This has to be a political decision. And I see your argument about the courts being more proactive about advancing LGBTQ plus rights, but I think in the European context or the continental context, it's a bit mixed bag. So, for instance, the very precedent case, which was an Italian set of cases, Orlandi and Oliari, in 2016, 15 and 16 from the European Court of Human Rights, they were announced when the court was already aware that the Constitutional Court in Italy said that, we should do something about this. And the social surveys or the were showing that there was a big public support for this. But of course, for political reasons, the legislators were still sort of stalling that issue. So then the court announced Orlandi and Oliari that it was implemented in Italy, and this started a set of cases from Eastern European countries where they have no hope for ever passing it through a parliament, so they do it through the European Court of Human Rights. But again, I think the European Court is very cautious in that. Because it also reflects on the European Court's legitimacy. If it just passes liberal judgments or progressive judgments that are, ignored by the states, then, what's the point of it?
Well, and also that it is a super body above these constitutional courts.
Yes.
Too.
Yes.
Well, thanks. I thought this was fascinating also. Thank you so much. And I love seeing that. I feel like that message about abort the court is like all over the world, like as a sort of resistance to the courts. Excuse me, but I just wanted to, if you were thinking about making part of your paper a response to Tamanaha or a challenge to him, right? I think you have the perfect set of examples. Sorry, I'm not contagious. I'm getting over it. Because what really struck me is you had the statement by one of the women talking about social media, and basically she was saying in social media there's no gatekeeping, right? But in the courts there's a lot of gatekeeping, and Tamanaha's work is based on US courts, which are very, very different from what we saw here in the sense that, to get something before the Supreme Court is extremely rare and hard, and it's only elite lawyers who can do that, and they're almost all men, right? There's only been a handful of women in the entire history, even, speaking in oral arguments at the US Supreme Court. But that, so what I thought was so interesting is when you think about the responses to Dobbs and then the responses that we're seeing here, the women of Poland seem to know that they can go to the European Court of Human Rights, so they can mail something and they can send in their information. And in the United States, women can't do that. You can send a letter to the court, which they'll throw in the garbage, right? And the only corollary I can think of is the Inter-American Court of Human Rights, which the US is a part of, but I don't think most American women don't know that at all, and most American lawyers don't know that. And so I'm wondering if that's, an interesting avenue for people here to pursue, but also to kind of peel back some of these other statements about, when someone like Tamanaha is talking about society, like you said, he's only looking at this one elite group of society who are represented in government already. And the corollary I can think of is there's the case of Jessica Gonzalez. I don't know if you heard of that case. So that was an American woman who got a restraining order against her abusive husband, and then he kidnapped her daughters, and she went to the police to try and enforce a protective order, and they refused to do it, and he murdered himself and her children. And she went all the way to the US Supreme Court, and they said that protective orders were discretionary and not mandatory because she didn't have a contractual right in enforcing the protective order. But that's the only kind of court order that's discretionary by the police to enforce, right? If I have a bankruptcy order against myself, like, that's not discretionary, right? And she went to the Inter-American Court of Human Rights, and they held that protective orders were mandatory, and they issued a judgment against the police department and the United States. And unlike the European Court of Human Rights, the US totally ignored it. And in fact, in Indiana, in case anyone wants to know, protective orders are discretionary and not mandatory still, which people don't know, right? They think they have something that can protect them. But it changed it changed a lot of the dialogue and the debate over protective orders, and people went to different states and got laws passed to make it mandatory, right? So I just think that's an interesting, but that's an avenue that American women don't know that they have, right? And I think just really kind of highlights some of the exclusion that leads into kind of exclusionary views of what's reflected in society and law.
So I would respond in two ways to that. I think there is also another way from which we could criticize Tamina, because I think I totally agree with you that he sees it from a very specific Western perspective, and yet in the titles he calls it a general jurisprudence of law and society, right? And I think in the spirit of decolonization, we really need to push back against those texts and the idea that the West created a golden standard that everybody should follow and where everywhere applies. And that's sort of I'm trying to do in this paper to push back against this Western standard. But in terms of the women who applied to the European Court of Human Rights, they wouldn't have done it without the lawyers. And these lawyers are the elite lawyers. These are the lawyers who work in the European Court of Human Rights, who have experience in representing applicants in other cases. And I had a few quotes earlier on which showed how naive these women were, because in the earlier conversations they would say, "I just want to sue my government," and it's like, you can't sue the government, So this is why I said that they really needed the critical ally of the human rights lawyers who could translate the grievances into something that would be achievable. And that case also, I think, is important because it sort of introduces the question of a potential victim. Because there's at the moment, every Polish woman in reproductive age can be a potential victim of that law. But the European Court of Human Rights so far has been extremely cautious about this potential victim doctrine or figure in law. And so I'm also see how this is gonna work out. The last time potential victim was invoked was in a Sass versus France case, which was the famous burqa ban case. So the Supreme Court in France, probably the Conseil d'État, said that we should ban full face covering. And a young French woman said that, sorry, this really affects me. And then her lawyers sort of introduced this idea of a potential victim, and the court admitted it then. So to me, then she unfortunately lost the case, and it's a rather dark chapter in the history of the European Court of Human Rights. But to me, it's also interesting how the Polish lawyers, really crafted that argument in reference to that Sass case, which is, miles apart.
Yeah, I have a question to follow up about actually, that third side of the women appearing to the media, because they have, it seems to me, just from the symbolism that they're enacting, and probably understand half of it, that they also call to national colors, to the flag. They appear also like in kind of a long-term critique of societal infringements of their sexuality, of their freedom of movement, and their freedom to appeal to the European society for rights. And so my question is whether actually to strengthen your argument about the law as a mirror, or not as a mirror, but as a lens into society, to take that side of the activists before and after the litigation, see how they appeared in their own texts, in their own testimonies, and then really the symbolism of kind of the reference to the you call it the clothes hanger, and in resisting earlier on abortion, infringement, sexuality, and gender politics, right? The idea of Polish family, nature, and so on. So I think that's a brilliant in into making that critique stronger.
Absolutely, absolutely. I think the flag is really symbolical here, because the current government, or the majority, the parliamentary majority, seems to be putting this message that there's only one way to be Polish, and they really sort of, and that means heteronormative, family, traditional family, etc., values. And I think the bringing the flag breaks this narrative, or sort of pushes back against that narrative of you know, and then also the leader of the current ruling party said that, you know, he actually in one of his speeches he divided the Polish people, and there are Polish people and there's a second sword, you know, and some people bear the second sword as a badge of honor. So like my mom, for instance, she's got a bag, a tote bag saying, I'm the second sword. but others actually, I think, by, for instance, taking the flag and saying, no, I'm Polish, sort of really push back against that divisive rhetoric. Yeah. Well, thank you.
Any other question? So I have one very short question. Do you know whether the Polish women who are involved in this complaint and they complain to the European Court of Human Rights, do they cooperate with the women in other, for example, Central European countries? Because you mentioned Hungary, and yes, we know from Michał Wawrykiewicz that in Hungary judges are not so really involved in defending property. They are afraid of no one knows what. But how about Hungarian women? Do they have like the activists this kind? And is this like any kind of connection of cooperation?
So this Federacja na Rzecz Kobiety i Planowania Rodziny, so this reproductive rights NGO, they are part of a bigger network, which is called an ASTRA network of different women rights NGOs across all of the Central and Eastern Europe, but also Central Asia and the Caucasus. So they, for instance, what they do is, as I mentioned, this is not the first reproductive rights case from Central and East, from Poland for the European Court of Human Rights. There are others, but they, for instance, would be involved in the execution of this judgment. So they would be writing reports about to what extent the government really complied with the general measures or not. They would also be writing yearly reports about, you know, what's their situation, reproductive rights situation in all the other countries. So I would say they are networked. It's not solely Polish women. Yeah.
Absolutely. Agnieszka, again, thank you so much. It was great talk. So